Assalamualaikum warahmatullahi wabarakatuh. This is our part 5, or I think this is final part for the Zoom recorded lecture for the topic intention to create legal relations. So for this particular part, I'm going to focus on 3 types of letters, which is in connection to intention. Okay, the first one is letters of intent, and then later we are going to discuss about letters of award, and last one is letters of comfort. Okay, what is letters of intent? The acronym or short form is LOI, letter of intent, or sometimes also some other synonymous or similar phrases or terms used is memoranda of understanding, memoranda of agreement, because it also, indicates the intention of the parties. So LOI, basically, they are a device. Okay, they refer to devices used to signal, okay, to signify parties' agreement to the basic structure of serious negotiations to close a deal. Meaning that here, this is the first step before they have another or serious deal or proper contract later. And typically, it comes into play after a round of initial discussion and after signing of confidentiality agreement. That's the procedure. And usually it is a second round of more serious discussions about the proposed transaction. So before the parties actually affix their signature or sign, or enter into a proper agreement, then usually the first step is by preparing, by issuing letters of intent. Okay, so what's the purpose actually of the parties to prepare such a letters of intent? So usually, this is letters of intent is expression of what the parties intend to agree upon should certain circumstances arises. So the document, the letters, LOI, may even be made expressly non-binding. Usually it is stated clearly this LOI is non-binding whatsoever. It creates no legal obligation as at that moment of time. Okay, and then in terms of legal implication, whether is it valid, is it enforceable? It is valid, yes, but then usually parties cannot really sue based on letters of intent alone. So in other words, it is from the legal perspective, it is a worthless document, but they are very significant, very relevant and useful, usually in construction and engineering contracts, depending on the industry. But this is some of the typical industry field in which letters of intent are usually issued. So what's the purpose for construction and engineering contracts here? To enable a contractor to commence work. The moment they have letters of intent, mean that the parties are serious about it, so they can start commencing the work on site at the time. And then until later they sign a formal agreement or formal contract between them or execute a contract later. We have the case here. This is common law. The case is Thurif Construction Limited and Regalia Knitting Mills Limited. We want to focus on what the judge said in this case. So the name of the judge is Fay. Judge Fay said that in regards to letters of intent, he said that such a letter is no more than expression in writing, something in writing. And what? Of what? Of a party's present intention, current intention to enter into a contract at a future dates, and that generally, in a certain situation, it can have no binding effect. So I mean that it's not legally binding unless in exceptional situation or circumstances. Okay, that's basically about LOI, letters of intent. We focus on another one, which is letter of award. So the word itself, actually it is self-explanatory. Award is giving away something. Okay, so basically letter of award is sent but in a specific situation. It's sent by a client or employer. Okay, again in something in writing, written confirmation that it is sent to a tenderer, the one who submit tender. Okay, so what's the purpose? A confirmation that a tenderer has been successful and will be awarded a contract. So it is a step before the award of the contract. Actual letter, actual contract is signed later. So the letter forms part of the contract award, and this is the process of formally notifying a tenderer that they have been selected as the supplier for a particular contract. I mean, yes, you have been successful, so we are going to award the tender to you, and they are all being expressed in letter of award. So the aim, the objective, or the reason of issuing such a letter is to give the successful bidder reassurance and to allow them to begin preparation. I mean, they can start preparing, okay, toward whatever tender they have submitted. And then again, refraining from any commitment to legally binding. But at that moment of time, issuance of letter of award, still it is not legally binding. It's just like written confirmation, but still it is not legally binding. Okay, so again, that's always the question. Is it binding? Okay, are letters of intent, are letters of award binding? So if you were to refer to many jurisdictions, including Malaysia, okay, basically the reason or the purpose of issuing letter of award is to affirm that to confirm that purchaser has accepted a bidder's proposal and agrees to proceed to a formal contract or purchase order. So, but there must be a formal contract and executed later. So in terms of stages or step or phases here, actually this is a small step, okay, beyond a statement of intent. So if we were to draw a timeline, so it starts with letter of intent, later letter of award, okay, whenever it involves tenderer, okay. But again, yet, okay, before actual formal contract is being executed. And then again, in terms of whether it's binding or not, okay, what's the legal implication? Generally, typically, they are not legally binding. And so the real purpose is actually, but again, it gives the rise, okay, it creates some door, or it opened the door, okay, to proceed the discussion on clarification of details. Basically, it's a starting point, okay, for the two parties to start discussing about the details, okay. And also this is the Islam announcement of notifying or notification of the result of the submitted tender. Okay, but again, despite that it's not binding, it is a persuasive, okay, the effect or the implication, persuasive in litigation, because usually the one who wants to award the contract, they are supposed to award to the one who received letter of award rather than to another party. Because the moment the tenderer, okay, receive letters of award, right, they will start working towards it, towards fulfilling their tender. So they may have expended significant resources in preparing the proposal and also taking part in the next phase. They are ready to move to the next phase. So that's why even though it's not binding, but it's very, very highly persuasive. So that's the effect of letter of award. Okay, the last one, letters of comfort. Again, this is issued in a very specific situation. Usually it involves bank, okay, or we call it bank comfort letter, okay, or generally letters of comfort. So what's letters of comfort? Obviously, it is a document. So it is a document given by whom? By a parent company to the bank, okay, of its subsidiary in response to a loan. So it involves a loan, okay, given by the bank to the subsidiary. So parent company issue this letter of comfort, okay, offering some form of comforting, okay, that the parent company, so that the parent company say, okay, we will ensure our subsidiary who took the loan will be able to repay the loan later. So usually this letter of comfort, it will include statement of awareness of the financing. Okay, I'm showing you the example of letter of comfort later. And then a commitment to maintain ownership interest and degree of support required by the lender. So this is all the content, okay, the normal or typical content of letter of comfort. Again, we want to know what's the legal implication, okay, what's the effect of having the issuance of letter of comfort here. So usually they are being issued because they want to release the tension. Okay, they want to bring down the tension between lenders seeking to better secure their loan. Those who lend the money, okay, they want to make sure that their loan is secured, okay, to be able to be repaid later. And then on the part of parent company, okay, of the subsidiary company, they also want to give some guarantee. Okay, but then again, this is not the real guarantee that they properly signed the document of guarantee. Okay, but again, the purpose is just to provide some comfort, okay, towards the lender. All right, and if we were to compare Malaysian position with Australian and also English and New Zealand, okay, Australian courts consider that strongly worded, it depends on the word, the usage or the choice of the words. Okay, strongly worded letters of comfort, it will give rise to legal liability. Okay, it depends on the actual words used. But for English law, as well as New Zealand, okay, they said, no, there's no legal liability whatsoever. Okay, when we talk about letters of comfort. So most of the time you follow English law, okay, position. And this is the case from English law, common law. Cleanworth Benson Limited and Malaysia Mining Corporation Berhad. So it involves Malaysian company. Okay, reported in year 1899. Okay, this is the decision. Okay, English Court of Appeal held that letters of comfort had no contractual status, and actually they were unenforceable by lenders. It gives some comfort, but from the legal application, legal perspective, okay, it doesn't have any contractual status. And this is an example of letter of comfort. Okay, let's have a quick look here. For example, parent company, the one who provide comfort, put in this wordings. Okay, we hereby confirm that we know and approve of these facilities. Okay, and we confirm that we will not reduce our current financial interest in about whatever subsidiary company. And the last one, it is our policy, okay, to ensure that the business of the the subsidiary company is at all times in a position to meet its liabilities to you under the above arrangement. So that's basically example of letters of comfort. Usually it involves lender, okay, it is issued to the lender, or we call it creditor, okay, and then it is issued by the parent company, all right, to give comfort over the loan taken by subsidiary company. That's the typical scenario or circumstances. Okay, I think that's all we are done. Okay, I stop share. And